And
You
there
tell
we
me
go.
when to go.
Well, we're live now, but we can still wait, for 3 minutes till people actually get in.
Boo, how many do we have signed up and how many checking in?
He's not supposed to tell us.
Yeah.
Oh, but I know.
I'll send you a text. How's that?
You
I'll
text
send you
me.
a message.
You text me, my friend. It's just us here.
Right.
Yeah. Oh gosh, too funny.
Just those crazy people.
Good morning, everybody. How's everybody doing so far? Good morning. Let's see. So we are live. We have 84 people in the room right now.
Awesome.
All right. So would you guys like to know the number?
See it growing.
No. Here, Julie, I'll send you the message.
Thank you.
There you go.
Yay. Oh, what a great team we have here.
All right. We have 105 in the room.
All right.
And do they all have coffee?
Yeah, hopefully
I have the great news. I watched the share. I got my new frother this morning or yesterday from Amazon, my coffee frother.
Yay.
Nice. And I bet it only took 3 weeks to come in, right?
No, that I could get in a day.
Oh, wow. I guess coffee frothers are essential.
Mia just responded, no coffee. Lemonade, always, Crystal Light, low calorie, gotta hydrate, folks.
Oh, shredded wheat and bananas. That's good.
I'm back in business.
Yeah. All right. Well, we are at 10 o'clock. So if you guys, would like to start with the introductions, we're ready to go.
All right. I'm Julie Sugita. I think you've seen my face a few times over these last few weeks of Zooming together. And I really wanted to thank you all for attending this course on real estate and COVID. This is a state-sponsored course. We're trying to sponsor courses that do address the COVID issue that we're facing as fiduciaries and as members of PFAC. So we're really excited today to have Patty Gerke and Ron Greenwald here to speak to us. We have had a previous course on real estate, and this is an ever-changing dynamic. As I told Amy Olson, it's kind of like trying to nail Jell-O against the wall with what we're dealing with in and out. So with today's presentation, we have Greenwald and Gerke Realty team, San Diego's finest realtors and co-founders of the Senior Stay or Go program, which if you followed any of their previous programs, some great material there. Ron and Patty combined their real estate practices to be a driving force both in San Diego real estate transactions and also to empower the lives of our older adults. They're affiliate members and strong supporters of PFAC, and for that we're grateful. Together, they're co-hosts of the show Senior Stay or Go, which is a senior advocacy and enrichment series of videos, and are also co-authors of the best-selling real estate book, The Essential Guide to San Diego Real Estate. Ron has a depth of experience in corporate operations, finance, marketing, and mortgage lending. He completed his MBA from USC and earned his CPA certificate while working at one of the Big 8 accounting firms. Patty has also been a dedicated caregiver, a healthcare provider. She and I have a shared history in that healthcare background. And she's also had a successful marketing and sales career as a professional for Fortune 5 companies and startups before she embarked on her real estate career. Patty earned her MBA from the Keller Graduate School of Management in Chicago, Illinois, and that's why you'll hear her Chicago accent, Patty. Without much further ado, I'd like to turn this over to Ron and Patty and their guests. Thank you for being here.
Thank you. Good morning, everyone. And I heard Big 8 accounting firm and like an e-ticket at Disneyland. I think that dates me to everybody. A special thank you to Vu and Amy Olson for all their behind the scenes hard work and putting this on. And given the COVID curveball, I think we owe a huge bear hug and massive thank you to Julie Sugita, PFAC president. And then I wish to add a congratulations and much good luck to the new incoming president, Mark Olson. Patty and I want to take this time to thank you, the fiduciary, for the frontline work you do each and every day. Obviously, these are unprecedented times with no shortcuts for the future. Many of you act as a son, daughter, friend, family member, and we all know the physical and mental toll on one when placed in the role of caregiver. So Patty and I are hopeful that you are taking care of yourself, your mind, body, and spirit. I think I'm going to take this moment to say it's a timely phrase. This is time to turn lemons into lemonade. We should all be boisterous for the great works of the licensed private fiduciaries in California. You do solve pain points. Let's shout that from those majestic California mountaintops as to your role, the need for your role, and the positive outcomes when utilizing the service of a licensed private fiduciary. So thank you for what you do. Patty and I are located in San Diego. We service the entire county along with surrounding counties as asked. Our business-to-business model is to team with professionals such as attorneys, fiduciaries, aging life care experts, senior community directors, and those that serve our aging population. We do know a NOPA when we see one, and we know estates, trusts, probate, and downsizing real estate transactions. Actually, Patty and I have used the word real estate journey. Like you, we believe we have heard it all from the non-professional trustee and those beneficiaries. And here's how it goes. The first line from the first conversation with a beneficiary with siblings is, quote, "We all get along," end quote. The very next line that we heard from that same beneficiary is, quote, "My brother is a low-life loser," end quote. And then the third line from that same person is, "I do not trust my sister as a trustee," end quote. So after this webinar, during your Friday, hopefully Zoom cocktail hour that you will take part in, we ask that you visit our newly enhanced greenwaldgerke.com website, where we post a vast array of videos and blogs that we believe advocate, inform, and educate our seniors for best quality of life practices. And with that, I'm going to turn it over to Patty.
Good morning, everyone. So there are a number of guidelines and forms that have come out since we have been sheltered in place since the middle of March. And like Julie said, it's like trying to stick Jell-O to a wall because there are changes constantly. Some of the forms we're going to review today have been revised already 4 times. And there's probably going to be more reiterations by the time we're done. Initially, CAR, the California Association of Realtors, set up the guidelines for best real estate practices, which you have on the screen here, showing that we really should not be doing any open houses in person, virtually only. Virtual showings and meetings if possible, although in the last week or two, physical showings have enhanced and increased, and therefore last week, what Cal OSHA came out with is the fact that every brokerage needs to have a plan in place, a written plan in place, with a document that has pictorials or pictograms stating what is required if somebody's going to enter the home. And that should be posted on the front door of the home or right inside the door of the home. And it basically states that, similar to these guidelines, that if you're going to have a physical showing, it needs to be by appointment only. There should only be 2 persons in the property at a time. You should have a face covering, and you should provide wipes and sanitizer at the property, as well as soap and water at the kitchen sink should somebody want to wash their hands. So practice right now in showing a property means appointment only, means a lockbox that's coded, so not everyone can just enter a key card or use their app to enter. The fact that there should only be 2 people at once, and they should show social distance, sorry about that, while they're in there, and then use wipes to disinfect any areas that they've touched while they're in the property. Again, as of last week, every brokerage is to have a written plan, and CAR has actually provided a document as well if your brokerage hasn't provided one. So there are 4 new forms right now if you're going to be selling any real estate here in California during the pandemic. And we're going to take them form by form. It's not easy to see the forms on the screen, so I'll show you the form so you can see kind of what it looks like, and then we'll go through and be able to discuss each form. This form here is the listing coronavirus addendum or amendment. The reason it's got 2 names, addendum or amendment, is because if it's an addendum, it would be provided at the time you're signing a listing agreement. If you had a listing agreement and the property was active in the MLS when this form came out, then it would be an amendment to the existing agreement. It is a 2-page document. It is in its 3rd revision. The first item in this document allows you as the seller to decide if you want to show the property or not. You also need to be aware of the guidelines that were put forth in the previous slide, and a copy of that should be given to you by your listing realtor so that you can see what they are, because the link, the URL link, is actually on the document. It also states that you as the seller are going to sign a PED, which is our next form, which is also the form that every visitor to the property must sign, whether it's a potential buyer, whether it's a realtor, whether it's an inspector, or whether it's an appraiser. It also allows you as the seller to require any visitor to provide proof of funds and or a pre-qual letter in order to show the property. This is so that you can determine whether or not you have a legitimate buyer who wants to see that property and is entering that property, so that you can limit exposure within the property. Item number 2 on that document discusses the marketing activities that you as the seller want to allow. Obviously, the more activities you allow, the better for getting the property out to the market, but you can be specific. Item number 3 is the post-acceptance activities, which are the activities that need to occur for the buyer to do their due diligence and get their loan approved. Inspections, appraisal, things like that. So those are items that you really don't necessarily get to choose, but they're listed so that you're aware of them immediately. Item number 4 is the impact of limited access. So if you should decide that you don't want to provide access and you're only going to provide limited access, it's asking you to contact a real estate attorney to be sure that's really the road that you want to go down. And lastly, item number 6 talks about withdrawal of the property temporarily off the market. Say, for instance, something came up that was unforeseen and you need to remove the property from the market for a short period of time. That will automatically extend your time frame on the market. Form number 2 is the PEAD, which is the Coronavirus Property Entry and Advisory and Declaration. This document has actually been revised 4 times, not 3. The last revision allowed for more signatures because initially everyone had a separate piece of paper. Thank goodness now we can use these 2 pieces of paper for the potential buyer, the seller, the buyer's agent, the seller's agent. Anyone entering the property, whether it be an inspector or an appraiser, can sign this one document. But it does need to be acknowledged by all parties, and it basically explains and makes you aware of the risk of exposure by entering the property, and that you are voluntarily entering the property, and you need to protect yourself as well as others. It also states something very important in that if you come down with an illness, after you've signed this document and entered the property, you should report back to the person who took you to that property so that they can report back to the seller. The additional signature lines, like I said earlier, allows everybody to sign one piece of paper, which is 2 pages, but at least it's one piece of paper instead of, probably at one point there were 10 pieces of paper for one showing. The third document is the coronavirus addendum or amendment. Again, addendum and amendment. So it has multiple uses. This is only 1 page, but this is a very important document. And I want you to notice the boxes for number 4 and number 5, because those are very important parts of this document. So again, it's in its 4th revision. Item number 2 says this document is not valid unless it's assigned by both parties, meaning buyer and seller. Item number 3 notes the next document, which is called the NUCC, which can or cannot be attached to this document. It all depends what you're using the document for, because again, this document has multiple purposes. Items 4 and 5 are separated by those boxes, and they're separated for a very important reason. If you're going to use the document for item number 4, that's one use. If you're going to use the document for item number 5, that's a separate use. So in item number 4, it allows you to request an extension of time for removing contingencies. So if the buyer can't get their appraiser in fast enough or can't get their home inspector in fast enough, then they're going to need an extension of time. At that point, they can include the NUCC describing what they're requesting that extension of time for. Once they provide this document with the NUCC, the extension time frame begins when the NUCC is delivered. Item B is asking for an extension to the close of escrow. This can be a request from the seller or the buyer, because something COVID related can come up on either side of the transaction. Once an extension for close of escrow is requested, it is from the original date of escrow being requested or assigned. So there's 2 different time frames here. The other reason this box is very important is when you're requesting these extensions, there are boxes to check regarding the buyer's initial deposit. Do you automatically request or provide that deposit should the buyer need the extension and put it hard in escrow? Or are you going to allow the buyer to get their deposit back minus fees no matter what happens? And lastly, box 5 is if nothing else can be done at this point in time and you have mutually agreed to cancel this transaction. There have been a good number of transactions since March 15th that have been canceled due to COVID by either the buyer or the seller. So it's not a one-way street. The buyer may lose their job, the seller may lose their job. There was a situation where the seller lost their job and couldn't now get the loan they needed to purchase their replacement property, so they could no longer sell the property they were in or have no place to go. So there are a lot of different circumstances that are coming up these days, and the key to all of this is patience. Patience and just trying to be very, very communicative and understanding what's happening as often and as quickly as possible. The last form is the Notice of Unforeseen Coronavirus Circumstances. And this is the form, again, it's 1 page. It is in its 3rd revision. It can be or not be provided with the previous form, but it's good to provide it and really explain what it is you're asking your contingency timeframe extension for, whether it be for contingencies or whether it be for close of escrow. So it just helps everybody better understand in writing, no misunderstanding, he said, she said. We put in writing why we're making this request. There are also 5 new forms if you lease or rent a property. And I'm not going to get into all of these forms because today we're lucky enough to have our guests, Frank and Don McLean from Heartland Property Managers here in San Diego. They have been in business since 1992, specializing in very unique real estate needs of fiduciaries and trustees who are desperately trying to fulfill their responsibilities with estates, trusts, conservatorship, and guardianships. They strive always to provide excellent service and support, and their staff is committed to a full array of real estate services to remove the concerns that are far too often, especially in today's environment, of producing issues with leases and rentals. And so I'd like very much to introduce Frank and Don McLean. Thank you so much, gentlemen, for being here today.
Good morning. So coronavirus and property management need to recognize what the focus is, and really the most important thing is to avoid liability. Way to do this is really with strong communication with your tenants or your residents, providing information to them, and then documentation of all of the communication that you have with them. We've received regulations from federal government, state of California, from counties, many cities, as well as the Judicial Council. So there's a lot to keep abreast of. And these mandates and regulations haven't stopped coming in and probably won't for the foreseeable future. We do recommend that as soon as possible, you initiate communication with your tenants regarding the need to comply with health and safety requirements in this environment. And this includes eliminating or postponing all but the most essential contact with tenants, including maintenance or repairs, with the exception of repairs absolutely necessary to avoid creating additional health or safety issues or physical damage to properties. You need to understand the tenant's perceived needs and situation, not if, but when a tenant contacts you with a negative situation. If not in writing, you need to transition the communication to a written format, such as email, so you have an excellent track of what's occurred, and you need to clearly document all the communication. First, I want to talk about if a tenant is reporting financial issues. You need to ask the tenant to clearly define their situation and make sure you understand. You need to explain the legal issues associated with the coronavirus regulations. Specifically, that payment obligations are not eliminated, they're only deferred, and the consequences for non-payment have been delayed. If it is related to COVID-19, there are requirements for tenants to provide evidence as to how the pandemic has created a hardship for the household, though these requirements vary in different areas of the state. We recommend that you do ask a lot of questions to let them know you're concerned and engaged. Things such as, can they make a partial payment? If it's a loss of employment, is it temporary? Is it a furlough? Is it likely permanent? And what are their prospects of returning to the same employer? Do they have other sources of revenue? And do they have a plan for their situation? They won't have answers to many of the questions, but the goal is to make sure that they know you're engaged, concerned, and that you want to work towards a solution.
Again, it's very important that all this is documented. Again, if it's not in email fashion, this communication, you create a file of organized communication notes after every single communication. And when you have these financial issues with tenants, one of the important things is you really want to evaluate the value of the tenant you have in place. Is this a quality tenant that you want to retain? And if so, is the trust, the estate, guardianship, conservatorship, etc., whatever it is that owns the property, and if they're in a position to do so, would it be well served for them to provide additional support or accommodations to the tenant? Some of those things can be a rent discount or reduction, during these times. And any other kind of additional support. And what you could do in exchange for that, you can extend the lease beyond what's currently existing. One other thing you need to consider when you're going over these financial issues with tenants is this a tenant that's taking advantage of the situation? And if you feel they are, you need to make sure that that tenant is cognizant of the exact repayment parameters and what the requirement is by your local governments and what the expectation is from you once the restrictions are lifted. Another item that you're going to be talking to your tenants about is repair or maintenance concerns. When those concerns come in, you need to clearly document what those concerns are and also be aware of the tenants or the residents' individual circumstances. Let it be their age, pre-existing conditions, etc. You may want the tenant to be out of the house when these repairs are being done. And if so, you may want to have it disinfected once the repairs are completed. Now, when those maintenance items or requests are reported, you need to question, you need to understand how the reported concern is going to affect the tenant, resident, the property, and ascertain as to whether or not this is a maintenance item that warrants the risk associated with authorizing maintenance personnel to enter the property at the time. You need to determine if there's a health or safety concern associated with the maintenance, or if there will be additional property damage done if the repair is not taken care of before the risks diminish. When you have to go in, you need to engage a repair or maintenance personnel who can provide information to you as to their own protocols for the current viral concerns and commit to the use of social distancing requirements, gloves, masks, sanitizers, etc. when they enter. And when they do enter, the repair and maintenance personnel should be instructed to make the necessary repairs performed in the most minimally invasive fashion. What you need to understand is that sometimes this may mean that some unnecessary finishing work can be done once the restrictions are lifted or relaxed.
It is important to clarify the entry criteria with both the tenant and those entering the property your direction. We recommend that you do obtain written acknowledgement of responsibilities and risks from both the tenants and those entering the property. And as Patty mentioned earlier, the California Association of Realtors has created a coronavirus property entry advisory and declaration form, which when signed by all parties, fulfills this important step. Next, I want to touch a little bit on the financial impact to your clients. For each situation, it's important to evaluate the financial impact on the estate or the trust should the rent revenue from the property fail. If the loss of revenue stream is a significant issue before it occurs, I think you need to consider what the probability is of your tenant's ability to financially recover is. If it's a high probability they'll be able to recover, then you just need to understand how a temporary shortfall of income is going to affect you. If it's a low probability, consider making alternative plans to sustain the entity, including the possibility of the total loss of expected revenue for several months. Consider, are there other sources of revenue available if necessary? What expenses can be trimmed for the short term if need be? Proactively consider what a tenant repayment plan option might look like and if that's a consideration. Need to create and implement a policy regarding notifications. In advance of being notified by the tenant, you can decide how you want to communicate with your tenant regarding these regulations that have been put into place. Again, the California Association of Realtors has created a couple of forms dealing with the non-payment of rent due to this crisis. They are the form NTAP, a notice to tenant of ability to pay rent during coronavirus pandemic. This form is a written notice to the tenant that there are orders created by various governments to abate rent payments requirements for a certain amount of time. Some people are immediately distributing this to all their tenants, while others wait until a tenant actually notifies them that they are having difficulty paying the rent. The other form is the form RPD, which is Coronavirus Rent Payment Delay and Repayment Agreement. This form is a framework for the parties to understand what questions and issues need to be defined in coming up with a repayment agreement. It might be a good idea to provide a blank copy of this after you receive notification from a tenant regarding their hardship, so they know what will need to be answered as an agreement for repayment is developed.
As you're dealing with tenants with the repayment issues, you're also going to be dealing with vacancies. Whether that is a vacancy because the tenant has financial hardship and has to leave, or whether they're moving just because they need to move during the time. Now, if the tenant is leaving because of financial hardship, they have a balance with you, they owe rent, and they leave. At that time when they leave, their balance is due at that moment. Now, a lot of the times when they have that situation, they're not going to be able to just pay that balance. So you need to work with that tenant to develop a repayment plan, a stipulation agreement, or some other form to get you set up an agreement to get you repaid. A lot of times you're not going to be able to enter that agreement with somebody. They're just going to up and leave because they can't handle the financial hardship it has. And in that situation, you need to be able to obtain a judgment against the tenant once the courts reopen. Regardless of the payment issue or the payment situation, what you need to do is immediately utilize your preferred vendors for a rent-ready status, consider your options for disinfecting the property, and immediately work towards finding a new tenant as soon as possible who is financially capable of fulfilling the rental obligation. Either situation, you need to have a plan in place to safely market your vacancy. And every situation is going to be unique, so you got to fit to your situation. The best and safest way to do this is to set up a professionally licensed disinfecting crew to go into every unit or property you show after every showing. What you can also do is set up what we like to call touch-free showings. What we do is before you have a hosted showing, you or whoever's doing the showing shows up a little early, turns on all lights, opens all doors, and then when a tenant or prospective tenant arrives, you instruct them to make sure that they're adhering to social distancing, wearing the masks, gloves, hand sanitizers, and they're also going to sign that entry disclosure form to protect you and also protect themselves. Other situations and when they're in the unit, you want to make sure that if they want to open a cabinet, turn on a light, or touch something, they instruct you to help them out with that, just to limit exposure. Another situation that we're doing is offering either a virtual or some kind of video tour. You can do either pre-recorded videos, walk through with the camera, phone, what have you, walk through, just do a virtual tour, upload that video to YouTube and include it in your marketing, or when somebody inquires, you can send them that video. Another situation we've also done is just set up video call tours, where they're using Zoom, Duo, FaceTime, whatever medium you want to have for a video virtual call. Set up a time, you call them from the unit, show it to them that way, or they can be outside while you go in. Basically, you want to find any other medium that's really going to help you adhere to social distancing rules, protect you, protect your clients, and protect the prospective tenants.
Wrap it up. In conclusion, just want to try to get to where we're using electronic documentation or electronic methods of payment transfer for dealing with tenants and in these properties. In the last few years, we've come a long way with the electronic signatures, the options for getting documents signed via electronic methods. We recommend that you're set up to have applications, all the documentation regarding accepting tenants or evaluating tenants to be provided electronically, that you're set up to receive payments electronically, and that you're using the electronic methods for all forms of your lease agreements, your disclosures, your documents, as well as your record keeping. And that would also include not only on-site records, but the ability to back up everything you have off-site, so that in the event of a catastrophic failure, you have the documents or the records available to you. That's it for us. Thanks so much for your attention.
Thank you, gentlemen, very much. Appreciate it.
Overall, the world of high tech, with all its intrusions into our daily lives, may also be the answer properly used to have the maximum return on your client's quality of life. We know it's been incredibly frustrating for, if not all of you, because you have not been able to see your client and visit the client and making sure that their care is properly attested to, especially in a senior community. We have heard those stories over and over again, and it's heartbreaking. So again, we're just offering you some ideas. I'm sure we're on a Zoom now, so Zoom, FaceTime, app, maybe your client. We do have, Patty and I have had 90-year-old clients with an Apple Watch that gave up all their credit cards and just go to the grocery store and there they go. So the Apple Watches can be very informative in getting information as to their health concerns and things like that. So maybe something to get to the Apple store and get your client an Apple Watch. I have no Apple stock. I'm not promoting Apple at this point. Other companies that you may want to examine: Great Call, Soresta Health, and Electronic Caregiver. Great Call offers senior cell phones, medical alert systems, mobile phone alerts to help seniors stay safe. Soresta Health is a much more deeper dive, and I think Great Call, it supports primarily family caregivers that are caring for those who struggle with self-managing their health, AKA dementia. Electronic Caregiver is one of the fastest growing health and safety monitoring companies in the United States. And they are introducing artificial intelligence into the equation. They have named their product, and again, all very Google, you can Google all of this, obviously, named their product Addison, and it is literally a virtual caregiver. I think we all need to embrace that's the future. I am sure as we speak, the investors, owners, developers, operators of senior living communities are poring over ways to reduce the human interaction of staff and residents with residents. Top of the list of frustrations during COVID, as I said, is not being able to see your client. Is your client receiving the proper care without you being there to check on the staff at a community, or being able to go see your clients in their home? So this technology is able to digitize the care with you. Maybe we can digitize the care and you are part of that to monitor your client's needs, health, and care in real time. How does that all going to impact your practice moving forward? That's a workshop for another day by somebody else. Selling real estate in today's pandemic. COVID-19 has put all of these 3 bullet points on this page on supercharge, overdrive. Home inspections. This may be a common practice where you are located or in your practice, but it may, and if not, you may want to realize that this may be a situation where you consider doing a home and seller home inspection and termite inspection prior to the listing of the home. The more we can do to avoid the requests for repairs, for credits, for price negotiations, once we are in the escrow period, the better for all of us. Pricing adjustments, as you know, can have an impact on the NOPA. It gets beneficiaries all fired up, and it just creates havoc in all your life. So the more we can do up front, the better for all of us, and COVID-19 has certainly brought that more to the forefront. Disclosures, even if it's just the exempt seller disclosure, fill out everything prior to listing the home. Have your realtor post everything as an attachment to the multiple listing service. All of us with experience throughout the state of California in this will say the same thing. You do not get sued for over disclosing what you know about the property. Over disclose. Today's lending environment. Your realtor, if you're the listing agent and you have gotten offers, your realtor should double and triple check the pre-approval letter, verification of funds, where the money's coming from, how the money's being derived, and the mortgage broker, that it is all above board. If you have a mortgage broker on your side of the listing side that is willing to take his or her time to cross qualify, I think this is the time to do that. Down payments, credit scores, debt to income ratios, cash out refis, all are just got revised, are harder to get, harder to obtain, and are going to continue down that path. One more thing, if you know that you're named in a document to be the successor trustee at some point in the future, your clients may be in a more stress, obviously, and more of a panic financial mode, and they may pick up that call. Again, if there's a reverse mortgage specialist on this and listening to this, again, there's a time and a place for all of it, but we have gotten, Patty and I have gotten several calls from people wanting to take on a reverse mortgage because of COVID-19. So just be aware of that. You may not be in charge today, but at some point in the future. So I would literally talk to your clients that if they get calls about this, to call you immediately. And that's it for that slide.
So there are a number of local ordinances and guidelines that have been put forth by the California Association of Realtors that goes back to those best practices and guidelines. But remember that there's federal guidelines, there's state guidelines, there's county guidelines, there's city guidelines. So it really depends where the property is, and you need to be aware of that. And there is a document which we'd be happy to make available to you that again has been updated 3 times. The last update was May 4th. I'm sure there's another one coming since we're May 15th. It's overdue. But it basically goes by county and city about the ordinances and guidelines for real estate, best real estate practices. So if you're dealing with properties in multiple counties or multiple cities, understand that what one person can do may not be what the other person can do. So you just need to be aware of that. And on top of all of this COVID-19 and pandemic stuff that's come out in the last 2 months, on top of that, the California Association of Realtors made some changes to how you can list a property, how you can show a property, when you can show a property. They're going to be adding a coming soon status to the MLS. So they decided to just muddy up the waters a little bit more and put some new showing instructions and how you manage your listing instructions differently as well. Eviction moratorium, again, this chart is by county. Please be aware of what it states. This has also been revised multiple times. The last revision was last week, so we're probably going to see another revision soon. But again, it's different for every county. And sometimes even the dates on these revision charts change if you listen to the daily update from the governor or your local mayor and see that that's changed. And just know that your city restrictions are number one, especially because they're usually more strict than the county and much more strict than the state or the federal government at most times. So again, this is another chart that we can make available to you. As Don and Frank mentioned, there are a number of disinfection services out there. These just happen to be a few that we know of, but there are a number of companies now that are offering these services so that you can be sure that even if you have the home staged, the stagers are even disinfecting the home once the home is staged for you. So just know that these services are out there. They're being used more and more every day, and we're happy to help you find the appropriate service for your needs. So now we're going to take some time for questions because I think there's a few of them.
Hi, Patty. Yes, we do. And for everyone that is on the webinar, if you could please put the questions in the Q&A panel, please. All right, so we got 24 questions in the queue right now. First question, who carries the obligation to sanitize the property after showings? Is it the realtor or the homeowner?
So if the property is vacant, then it's the realtor's responsibility to have the appropriate disinfection materials at the property if they're not there for every showing. So you need to have wipes, you need to have paper towel and soap at the liquid soap, not bar soap, at the kitchen sink if somebody wanted to wash their hands instead. You need to have sanitizer. So initially they said people should wear gloves. But what happens is people are wearing gloves multiple times. And so that's really kind of defeating the purpose of wearing the gloves. So now we're to the point of saying, if you want to wash your hands, there's soap and towels at the paper towels at the kitchen sink. Please take that paper towel with you. And if not, you want to use sanitizer, the sanitizer is there at the front door the minute you walk in the property, as well as wipes. If the owner is still living on the property, then it is the owner's responsibility after every showing.
2 persons at once. That means realtor and one other?
Correct.
Okay.
Yep, correct.
Can
Or what
a
a lot
home-
of times the realtor is doing is allowing their 2 clients to go in, and then when they exit, they'll go in after them.
All right. Thank you, Patty. Can a home be shown to a potential buyer if it has tenants? What notice is required to be given to the tenants?
I'll let Don and Frank answer that one.
The answer to that is, generally speaking, it can be. The lease agreement is going to dictate. The California Association of Realtors lease agreement does have a provision that the property can be shown. However, in this time of concern, we don't really recommend it. If the tenant is objecting to it, we avoid pushing that at all. If the tenant accepts it with the proper notice and disinfection and everybody understanding what the rules are to enter, no touching anything, then it can be done. But again, it's my opinion that it shouldn't be pressed. It's really going to be up to the existing tenant given the current situation.
And actually to add to that, I would also recommend, I'm actually in a situation with that right now, where if you have a situation where a tenant's living there and you want to show it, do a video tour of it. Go in yourself, do a video tour, and provide that to people who want to view it, just to protect yourself, protect your tenant, and protect your client.
Thank you, gentlemen. Next question. How, if at all, might any of these property management rules, regs, suggested policies differ for out-of-state properties?
Definitely, you're going to need to contact your local real estate, a local real estate agent or property manager, because literally every state and almost every county has their own set that don't necessarily comport with the county neighboring or the state neighboring. Many cities, the judicial activity is also something to be considered in many states. So it's really depending upon where you are, you're going to have to speak with the local company, a local company that understands what's happening in that region.
Thank you. If you already have a property listed, should you go back to the realtor and have these signed?
If you have a property listed and it's currently active, not in escrow, I would have them signed just for safekeeping. I would have the RLCAA signed and the PEAD signed.
Thank you, Patty. I will be selling commercial property. Does this apply to that type of property?
I'm not a commercial broker, but my understanding is these guidelines all come from the California Association of Realtors and or Cal OSHA, and it applies to any real property.
Thank you. Are there any COVID-19 laws protecting commercial tenants and allowing non-payment of rent? Are unlawful detainers being processed?
That's a good question. Again, I'm not a commercial broker. I have a good friend who is. I don't know about unlawful detainers for not paying rent, but I know that they are all scrambling right now to try and find a plan and means to safely have their tenants re-enter their properties. But that would be more of a question for a commercial broker.
I would add that because the courts are closed, there's the ability to initiate action, unlawful detainer action, just to essentially get yourself in the queue, if you will, of coming litigation regarding unlawful detainer actions or evictions, because it's likely to be pretty large once the courts begin to open. So if it's commercial property, I would definitely recommend that you discuss this with your attorney, just because of the nature of the current situation with the courts, as well as the regulations that continually evolve.
Great, thank you guys. Is there any time frame for how long all these forms will be required? That is there an end date after which these forms will no longer apply?
Oh, that's a loaded question. Honestly, we have no idea. I mean, they keep revising them, and we honestly have absolutely no idea how long they will be required.
And it could be different and different. It will be different in different cities, different counties, different areas.
As they open up.
Yeah.
I think until there's an eradication, I think everybody's going to do a CYA on these forms, and that's why they're being revised continually and updated continually. They are a moving target. So you can certainly count on 2020 that these forms will be in place.
Yeah.
And no sports, bummer.
Is the extension of time mandatory, or can the seller elect to withdraw from the contract?
It depends how the contract was written, what boxes were checked, and how the communication's gone throughout the transaction. So yesterday I had a situation where we had multiple offers on a property. We had a buyer with limited down payment, and some of his down payment was coming from a cash out refi. Spoke to the lender doing the cash out refi at 1 p.m. Said, no problem. It's in underwriting for final review. We're positive this is going to happen. Got a call at 4 o'clock and said, guess what? We're not authorizing this cash out refi. Now the buyer doesn't have the remainder of his money for his down payment. So things are, when we say things are changing literally by day and by hour, we're not kidding. You just have to stay on top of it.
Thank you. Are these forms required statewide?
Yes. Yes, they are.
All right. Any news on when this may become available again? I'm not sure what that's actually in reference to. My apologies.
The evasion question about it.
Maybe it goes
was
with the
getting
eviction.
ready to evict, courts closed, and governor stayed evictions.
Any
Maybe
news?
that's
Any news
when.
on?
Yeah,
Yeah,
that's
maybe
it's a
that
part.
question's
That's a two-part question.
Okay, they're the two parts. Yeah.
Again, we just don't know when things are going to open up again. You'll hear when the courts begin to actually schedule hearings again, but there's going to be a pretty good waiting line. So I would talk to your attorney about filing, even though nothing's going to happen. At least you're going to get a number and be in the queue.
All right. Thank you. Do all the requirements you are outlining cover both residential and commercial, or only residential?
Again, we are residential realtors. We are not commercial. These documents are all provided by the California Association of Realtors. So I honestly can't speak to that.
All right. Thank you, Patty. I'd be interested to hear whether there's an official guideline about allowing bathroom use in a home being shown or where repairs are being made. That's obviously not minimally invasive, but it may also be distinctly unavoidable. And as a practical matter, you can't expect contractors simply to run over tow to the nearest McDonald's, which will likely be inaccessible.
Great question.
That is a great question. If someone's on the property doing repairs, they're probably going to need to use the restroom, and then that restroom is going to need to be disinfected once they have vacated the property and all the repairs have been completed. During showings, you have no soap, you have no toilet paper, all you can do is have a sign that says, please do not use the restrooms, although they don't even want us to have flyers or any kind of paperwork within a property right now. That is the best you can do with a vacant property. If the owner's living at the property, I would use a little Lysol after every showing in the bathrooms if there's any notification that the bathrooms have been used.
I mean, obviously, if there is going to be one bathroom, this is the one, and just have a couple, all the Lysols and all the wipes in that bathroom. It's best practices, and just document, take pictures. I would take pictures of all the stuff that you have in the bathroom that was there, so that if anybody used it, there can be no reason that they didn't have the opportunity to clean it as they left. Right?
Yeah, it's really going to depend on each situation, as everything's unique. You know, tenants and residents, they may not want a vendor using the bathroom.
Yep.
It's really a case by case situation. I haven't heard any specific rules on it, but it's really just protect yourself, protect your clients, protect the residents as best you can.
And if you're going to have a lot of work done, have a porta potty delivered.
It's worth the investment.
Great. Thank you. For the rental forms mentioned, can someone send out a list of these forms and where to get them?
Well, the list of forms is in the presentation, and you will get a copy of the presentation. And any realtor you work with can provide those to you. They are California Association of Realtor documents.
Thank you, Patty. I think client has to have a smartphone via Great Call. Might be worth upgrading. Client needs help with making a call.
I
Go grandparent.
I did not understand that because I know Great Call provides the Jitterbug phone. That is not a smartphone. So I honestly don't know. That's a good question.
I mean, just that there is a company called Go Grandparent, and they are a broker for Uber and Lyft, so there's an upcharge to their services. But if somebody's not able to use a smartphone or unwilling to use a smartphone, Go Grandparent is a intermediary that can tell the loved ones or the fiduciary where their client is going or who they're calling.
And it can be used with a flip phone.
In a flip phone.
Thank you. Where to get the list such as eviction moratorium?
You can either email us and we'll provide it to you, or we will provide it to Vu and he can distribute it.
Does owner need to notify tenants of maintenance entry via verbal or forms? How much notice in advance is required?
The owner does need to notify the tenant and have the conversation as we discussed about whether it's an absolute necessity or if it's something that can be postponed. The letter of the law is that you have to give a 24-hour notice if you're going to enter the property. But once again, having a discussion with the tenant and the owner as to the risks involved or incurred by forcing an entry if the tenant is not prepared to allow it. I think you need to be very careful in forcing that to occur. There's definitely some issues that do require entry, and if that's the case, it would not be a bad idea to discuss it with your counsel, just because you want to make sure that everything is being done to not put the owner at risk or to put the tenant at risk, or whatever risk is incurred does not inure to you.
Great, thank you. Are buyers really willing to buy based only on a virtual tour?
That's a great question. That is really a great question. So yes, there are some buyers that are willing to purchase based on only a virtual tour, making their purchase agreement contingent upon entry into the property and doing some investigations, whether it be a home inspection, a pest inspection, whatever. But most times than not, it's clients that have relocated a number of times and are used to buying homes in a variety of different ways, or it's someone who has targeted a specific neighborhood, knows all the floor plans, knows the community very well, and the one house that they've always dreamt and wanted came on the market and they can't enter that home. But there is a little bit of a dichotomy happening right now, even though inventory is very low, which usually means a seller's market. Sellers are saying, if the buyer hasn't physically seen my home, why should I reduce my price because they haven't seen it? And buyers are saying, well, if I can't get in to see it, then you should provide me with a discount. So we have a little dichotomy happening between sellers and buyers in some markets right now. But yes, there are homes actually being sold virtually only.
I'll just add to that. There was an article yesterday in the Wall Street Journal, a company we may know of called Redfin, issued a report that there was a 110% increase in searches for properties in towns of less than 50,000 people. So there could be a second half of the year wave of, if you're in a big city right now in a congested area, people that may say, you know what, I'm done, I'm out of here, moving to smaller towns, whether it's in California or out of California, that I don't know. But it is going to be I mean, obviously we're weighing, 30 million layoffs, 40 million layoffs versus people that are saying, I've been this is not the house of my dreams. This is not what I want for my future. Will there be a more inventory coming on the market in the second half of the year because of that? Time will tell, and we'll see.
Great, great. Thank you guys. Wow. If all contingencies have been signed off and the property is in escrow due to the court being delayed, is this a valid reason to return someone's deposit and decide to stop the sale?
That has to be a discussion between the buyer, the seller, and their realtors, and they have to agree what it is they want to do moving forward. It's that, I don't know that that's a yes or no answer.
When you're saying courts, and then that sounds like a probate.
Probate, yeah.
A decision without going to the court if it's a probate case. I mean, Patty and I did have a situation where COVID, the buyer did walk after all contingencies were removed, and the result after weeks of negotiations were to split the deposit, initial deposit money 50-50. So again, that brings up a good point, is if you're selling a property, demand 3% as your initial deposit into escrow. Because again, that is the maximum that can be rewarded to a seller if the buyer backs out. But you certainly want that in there as leverage if down the road there's a request for cancellation due to COVID.
Wow, great. Thanks, Ron. In the sale of a property, as you know, as a result of the COVID-19 environment, many tenants are deferring their rent, which can be paid back for up to 12 months. Who does the deferred rental income technically belong to? Is it the seller or the buyer at the close of escrow? How would that be handled at closing of escrow?
Oh, wow.
These are great questions.
I can weigh in here a little bit. Generally speaking, it's going to be reflective of the close of escrow date, that everything before that that's earned would belong to the seller, and everything that would be earned after that would belong to the buyer. However, just because we're in such an odd environment, I think it's probably a situation that's going to end up being negotiated in the escrow, seeing as dividing that money is going to be somewhat problematic unless it's being paid to a property manager outside of the transaction that would then be divided between the parties. Very likely, though, it's going to end up with some negotiation.
Thank you. Fortunately, as of last week, I am in contract. Any particular issues, comments, suggestions regarding COVID-19 changes in the closing process?
There's the only changes to be diligent and have good communication throughout the process, because things come up, whether it be things coming up with the appraiser or the lender or someone within the transaction. So, lending restrictions are changing every day. So just having good communication with the buyer's lender, I think, is really important. And just have good communication.
Patty and I have a transaction, and the contingencies are due to be removed. The physical contingencies are due to be removed Monday, but we're not waiting till Monday to have the shoe drop, so to speak. We are asking for daily updates so that part of this is a COVID situation. We're trying to get information daily so that it's not a surprise. Nobody's surprised on Monday if another request for extension comes along due to exchanging circumstances, lending circumstances, appraisal circumstances, or just the need for time to get their ducks in a row.
Thank you. Is the seller or the realtor responsible for making sure that all of the new documents are signed? Who is liable if one or more of the documents isn't signed?
Transaction coordinator.
No, not at all.
No, not true. Not true.
That's a loaded question. It's the realtor's responsibility to provide the document and hopefully follow up and make sure the documents are signed. But as long as they have documentation showing that they provided the document, they've explained the document, and they have all that documented, then, you know, at some point, the other party takes some responsibility if they haven't taken the time to sign the document. But it is ultimately our responsibility to stay on paperwork, make sure it gets signed, make sure the file's complete. Our brokerages all have file reviewers to make sure the proper documents are in the file and they're all signed by the appropriate party. So there's multiple checks between us, our transaction coordinators, and our file reviewers within the company. So there shouldn't be any reason that the appropriate documents are not in the file, signed by the appropriate parties in order to close a transaction.
Thank you, Patty. Our ability to get mortgages affected.
Right now, we're not lenders, but I was just on a webinar last night at 4 o'clock, and there are some lending institutions that are not providing jumbo loans, or if they are providing a jumbo loan, they're requiring a much higher down payment, a higher credit score, a lower loan to debt ratio. And then there are some lenders who are just very, very picky about the requirements for their loans. Self-employed people are having difficulties. I have a self-employed friend who tried to refinance, no cash out, just refinance for a lower interest rate. And they kept asking for more paperwork and stalling and delaying. And finally, after 2.5 months, told him they wouldn't offer him the loan.
And yeah, that's just a continually monitoring situation because, again, the overlay, I mean, Fannie and Freddie is one thing. I mean, obviously the feds are trying to make sure there's enough money in the system, but the banks themselves will put additional overlays on their funding requirements or the lending requirements. And so you don't know, Wells is going to be different than Chase, Chase is going to be different than Citibank, and they all are going to have their own overlays as to what they will do based on their risks. So again, you have to continually monitor it, cross-qualifying, and making sure that that person, not just a pre-qual, but has actually thrown all the documents onto the table to their lender, and that lender's actually put it through an underwriting process, not just a glance at the documents.
Thank you.
I was there in 2008, so beware.
If the forms are completed, signed, but then revised, do you need to continue to sign the most current edition?
I would say yes.
I would say yes, just to be current with your paperwork.
Again, it's put it through DocuSign, get it done. Over. You can never be sued for having that second form in the file.
Better to have and not need than need and not have.
Exactly.
Yes. Thank you. If everything remains okay with current tenants, no issues with rent payments, do we still are required to provide any forms related to COVID-19?
You don't have to provide the forms. I think that, again, some companies and some landlords are providing the information that if people have concerns, there are avenues and there are orders restricting a landlord's response. We've taken the position that it doesn't seem to make sense to give that information to people who are not looking for it. It's available everywhere. Every newscast, every politician that gets near a microphone will tell you that that they don't have to pay rent. So people are aware, and it isn't until we get a query from somebody that they are having some issues that we want to make sure that they're aware of the moratoriums and the restrictions on how a landlord can react.
And I will add on to that, because I was talking to a lender. If somebody decides not to make a payment with this forbear or delay payment, I'm talking mortgages, not rent, but delay, and they get a letter from from a bank, and they say, oh, you don't have to make the payment, no big deal, just we'll put it in forbearance. That is, yes, that sounds great, but that is something that's going to impact their ability to refinance or get a new loan for the next 18 months to 2 years. It's not a freebie. It's a freebie in the sense of you're not making the payment, and you can delay the payment. But if you want to then move forward with refinancing in a year to 2 years from now, that's on the record as a forbearance on your file, on your credit report. So just be careful. What sounds too good to be true may be a little bit too good. And the reason, and again, there's a theory that some of these banks are doing this because they don't really want to offer this massive refi to lower rates right now. They want to keep what they have on the books. So by offering a forbearance and somebody takes advantage of it, now they're stuck with that loan for at least another 2 years. So just, again, do due diligence as to what your needs and wants are.
Thank you. If a tenant presents you with a request for repair, are we required as landlord/fiduciary to provide with any sort of new form to enter the property to assess the repair issue?
There really isn't a form regarding that. However, I do believe that it's important that the communication take place. Again, document any issue that a tenant brings to you with regard to these things. But there needs to be the conversation about, is this a health or safety issue? Is this something that's going to cause physical damage to the property? And in the instances where it is, then the California Association of Realtor PEAD form is going to provide some direction to all the parties entering and allowing the entry as to what they need to be aware of, and social distancing and gloves, masks, all those kinds of things to make an evaluation of what's happening. But again, understanding the nature of the problem, postponing anything that is possible to postpone until the risk diminishes is very, very important. But if you are having somebody enter, it has to be somebody that understands these coronavirus protocols and is prepared to use all the appropriate accoutrement for protection of the resident as well as themselves, and sign that they're acknowledging and aware to go in and make the evaluation.
Thank you. Now we have about 9 questions left, and you guys are still okay with time, right?
Yep. Yep. I just
Okay.
wanted to put our contact information up in case somebody did want to contact us.
Oh, great. Thank you. I'm gonna combine these 3 questions because they're similar. Sanitizing after each visitor, whether it's the house or even a bathroom, how does this happen when I never find sanitizer in any store? Supplies are not available, such as Lysol, hand sanitizer, masks. How do we deal with that? And the virus only survives a certain number of hours without a host. Do the disinfecting guidelines allow for that consideration?
Well, I'm not an epidemiologist, so I honestly cannot answer that question. That is a very scientific, technical question that can't be answered by a realtor. I apologize. We're doing the best we can with what we have available to us. And at this point in time, that is the best we can do. As far as supplies, hand sanitizer, you can make it. If you Google hand sanitizer, there is an easy way to make it with alcohol, and you can make your own if you can't find it. As far as wipes, I literally walked through every aisle of Walmart the other night and found wipes in aisles that they did not even belong in. So it all depends how determined you are to find what you need sometimes. But yes, it's not easy. But I think the stores are getting more and more of these supplies now that they're ramping up and things are going to be more available. But as far as hand sanitizers, you can make it. It's not difficult to do.
And to answer the question about the virus being present without a host, I think you have to protect yourself. There's nobody understands this very well. We certainly aren't the ones to be asked about that question, but you need to protect yourself, you need to protect your clients, and you need to protect people who you come in contact with. So you just need to assume that you need to sanitize regardless of how long it's been since somebody's been in there. You make assumptions about this that nobody understands, then you're just going to get yourself in trouble, and you're going to pose risk. So just assume that you need to sanitize no matter what, and I think that's the best way to move forward with it.
Great. Yes. Thank you very much. It would seem that the sanitation measures that are required by the state and local governments represent best practices and our civic duty, but I am not sure about the potential liability to a seller or a landlord. I can't see where a litigant could prove they got their COVID infection at your property and therefore make you liable for some form of damages.
Well, I tend to agree with that, but I've also seen litigation for things that are absolutely ridiculous that end up costing the litigants and any participant a significant amount of money for virtually nothing, but the time and money spent to defend yourself is not worth whatever the cost is to do this sanitation and follow these restrictions and regulations in order to avoid the accusation.
Yes. You mentioned go-go grandparent as a good possibility in helping our clients, but I've only found that gograndparent.com is Uber and Lyft. Is there another site I would go to?
For transportation, I don't know, where that, like down here in San Diego, we have Jewish families. I mean, obviously the government agencies that provide transportation, the county Health and Human Services may have it. Jewish Family Services provides they were, again, that's a good question. I don't know if they still are, but you just have to, again, if you have a 211 in your area, I would call 211 and ask them for senior services. That's probably what my suggestion would be.
Thank you, Ron. I know that we're on the front end of the shutdown, but can you talk about days on market issues on your listings? What are you seeing in terms of listing price reductions related to timing of reduction about property or after property is listed?
That is the $1 million question, because it is so specific to a certain area, even a certain website or a certain zip code, for instance. So you may be in a city like here in San Diego. Carlsbad has 4 zip codes. All 4 zip codes perform very differently. So as far as price reductions, we're not seeing a lot of price reductions unless you're well over the $1 million mark. But again, that's here in San Diego. That's not necessarily in Northern California, where they're not seeing any price reductions at all, probably. And as far as days on market, it really, again, depends upon price point and locale. The properties that are somewhere between 5 and 800,000 are still, a lot of them, seeing multiple offers and actually selling for over list. So it really, it's a difficult question to answer without knowing the specific area.
Thank you, Patty. Are sale commissions being...
We'll all sign in that in terms of, I mean, again, I think June and July, when the data comes out from the next couple months, you'll have a more of a clear idea. But I mean, Patty's answer is right on point. And then if there's an area that's more recreational, more of an Airbnb type community where there's lots of rentals in that area, I think you're going to have a different climate than if it's a residential area where people are looking to put their kids into a school and maybe get more land around their area where they are now. So again, very target zip code specific.
Thanks, Ron. Are sale commissions being adjusted, affected?
Not that I'm aware of. I mean, we're working just as hard, if not harder than we always have. So if you have a good professional who you trust and respect, they should be worth every penny.
Yay.
If the tenant gets to put off payment, what happens to the owner who needs to pay a mortgage?
That's a great question. I strongly recommend that you and all your friends write to your local politician and ask them that very question. There have been some banks that have agreed to some sort of forbearance or allowing loan payments to not be made. Of course, that doesn't that only defers payment. The interest is still going to be charged, but not every because it has agreed to that. Pretty much, it's the position of many who've made these eviction moratorium rules is that the landlords are going to have to come up with their own solutions. So there's talk about it, but there isn't anything that's really legislatively completed.
Thank you. Go-Go grandparent question was not talking about getting transportation. It is there. I thought Patty mentioned it as far as checking in with our clients and seeing how they are doing. Sounded almost video.
So Go-Go Grandparent is the transportation side of what Ron was talking about, but then there are the other two companies, Seresti and Electronic Caregiver. And Seresti they have caregivers that virtually come into the home on like an iPad and you can speak with them. And then Electronic Caregiver is a company that in July is going to introduce an actual artificial intelligence caregiver who is so intelligent that she can actually determine whether or not the person's gait has changed while watching them move around the house to know if they're becoming a fall risk. So that is huge, and that will be available in July. And if you're interested, you can always contact us. We have more information about that product.
And there is a question regarding a commercial question, if that's okay to ask.
We'll try.
Okay. Are commercial tenants eligible for rent delay due to lack of business, like residential tenants for loss of employment?
Wow.
Yes, they are. And again, a prudent owner is going to do what they can to retain a quality tenant. These are trying times and a lot of businesses are struggling. And it's very, very important that we try to support those that are doing their best to stay alive and continue to thrive. So there is some restriction on what can happen with them, but I strongly encourage landlords or property owners with a tenant who you would deem as a quality tenant, give them whatever opportunity you are able to in order to recover.
And that's it for the questions. But I would like to mention too, we did have someone in the chat mention that Costco.com has Clorox wipes in stock with 2-day delivery. And also that there's a company called GrandPad that shows face-to-face.
Oh, okay. That's good to know. We'll need to look that up. Thank you.
Yes, and thank you very much, everybody, for staying for the Q&A session. That was really great questions. And again, as a reminder, when you end and leave the webinar, you will be presented with the evaluation link. Once you submit your evaluation, you will have the link to download your CEU certificate. And if you guys would like to say anything else?
Thank you so much for taking the time to be with us today. We really appreciate it. And if you need anything, please feel free to reach out, and we're happy to help in any way we can.
Thank you as well. And you have our email addresses. If there's further questions, we'd be happy to answer.
Thank you.
Good luck.
All right.
Be well.
Safe.